A lot of street arrests.
Critics of the measure have pointed out that cell phone videos have been key in holding police accountable in cases like the 2020 murder of George Floyd. The American Civil Liberties Union and a coalition of news media organizations filed a federal lawsuit to stop the Arizona law. David Bodney is an attorney with Ballard Spahr representing the news organizations.
We've seen really nothing quite like this in Arizona, and the statute was remarkable as an outlier nationally.
The law is unnecessary, Bodney says, because other laws already prohibit interfering with law enforcement activities. He says there are also potential issues with enforcing the 8-foot rule.
Does that mean the police can seize a person's cell phone? Might they be seizing a cell phone of a person who is not recording, but merely looking at text messages or taking a photograph, which was not prohibited by the statute?
And even if someone were filming,
it's really unworkable when you think about it. Typical law enforcement activities involve multiple police officers, and one officer could say, fine, go ahead and record, and then another officer moves within 8 feet of the person recording, and suddenly there's a potential crime on our hands.
Kavanaugh says this kind of rule is not uncommon, and it should be easy to estimate the 8-foot boundary.
The U.S. Supreme Court said that it's constitutional to keep protesters back 8 feet from the entrances to abortion clinics. There has been no problem with estimating 8 feet. You can't park your car closer than 10 feet to a fire hydrant. I've never heard of any issue about I can't tell what 10 feet is. So that's really a bogus argument against the bill.
He says even if the distance becomes difficult to gauge, it should still be easy to tell when the rule is violated.
Besides, if there's a disagreement, the cop's going to make it clear when the cop gives the warning, you must get back 8 feet, that the person is not complying. So it'd be pretty tough for the 8-foot distance rule to cause problems.
Some say this law catches free speech in the crossfire.
It violated the First Amendment rights, not only of the press, news organizations, but of any member of the public who might pull out a cell phone to record.
Joseph Rusumano is a mass communication law professor at Arizona State University. There's a standard of law that there's no privacy in public, he says, which opens up government officials to being recorded.
If something is happening in public, especially government officers, then citizens arguably should have every right to see what they do, and as a tangent of seeing what they do, to be able to record what they do.
Kavanaugh says the main issue the law aims to address is officer safety. People can still record officers, he says, but must back up.
People you don't know sneaking up, especially from behind, can distract you. And even if they don't have an evil intent, during that distraction, you can be assaulted by the person you're contacting in an enforcement situation, or they can escape, or they can hide evidence.
Kavanaugh says that after a previous attempt to pass this bill, safety concerns were brought to him regarding people getting close to officers.
I got a call from an officer in Tucson saying there was a group doing that in Tucson, and it was very dangerous.
The group Bonnie represents has asked the federal judge in this case to permanently block the law. Kavanaugh says if the law is permanently blocked, he'll go right back to the drawing board.
I will rework this from now until doomsday until I get it right.
Bodney says he hopes Kavanaugh will approach a new draft of the law with the press and public in mind.
If he does go back to the drawing board, may he do it with our Constitution and our constitutional rights in mind.
Kirsten Dorman, KJZZ News, Phoenix.
And you can find this story on our website, kjzz.org. You're listening to All Things Considered.